Representative Lambert.
Mr. Chairman, I'm a bit confused. Isn't there a protection in our Constitution which indicates that any threat to liberty requires that someone have a hearing in Superior Court or above? Or did I misunderstand that? Or that protection, I believe, is absolute, and family courts are going and threatening to take people's liberty without due process of a court which is not an equity court. So how does an equity court have the ability to put someone's liberty at risk without full due process of law and accountability to our rules and statutes 100%?
Fascinating question. Representative Agar.
Follow up on that. The question of liberty, thank you, Mr. Chairman, is not necessarily just even that of incarceration, but also property and family being taken away from him. That is also a violation of his liberty, correct?
Liberty interest.
Yes. We'll let Mr. Vandenberg talk for a second.
No, it's a violation of a fundamental liberty interest. No, liberty interest.
Please expression. Make sure you pay attention to these in your thinking when we get to the recommendation part. We'd like to close out before noon.
A liberty interest is just fundamentally any kind of right that we have that existed before the Constitution. Have a family, raise a family. Marriage is one form of fundamental liberty interest.
Right.
So those are, in the federal Constitution, those are in the 9th and 10th Amendments, and it's in the New Hampshire Constitution, but I forget where. Those are protected interests. The government can't just start regulating raising a kid. And that's one of the things that happens very much. If you're with the appointment of guardians ad litem, it's problematic. Because if you're married, you have kids, the government's not going to come in and tell you what you can do with your kids. You have to do this, you can't do this, you have to do that. However, if you get divorced in the state of New Hampshire, the government automatically appoints a guardian ad litem who has absolute quasi-judicial immunity. So, you know, Katie barred the door, you don't know what she's up to next. But these people are appointed as supposed attorneys for the children to represent the children in court. So now you have a situation, an adversarial situation against your own children that the state has imposed upon you because you're becoming divorced. So now this person who supposedly represents the interests of the children is at you. They can arrest you, they can have you incarcerated, they can try and get as much money as they can out of you, they can take your children away for 2.5 years without any recourse. And that's the difficulty with this. You have a guardian ad litem program in which these people have no accountability and they have all means at their control to defraud people of their assets and their families.
So in answer to the question about liberty, though, are you bringing a federal court or some other one that would invoke the federal Constitution or even our Constitution in relation to this stuff that you've been dealing with?
I didn't hear the first
I'm
part.
asking whether, in relation to the issues of liberty that you've discussed, which you obviously feel infringed upon, regarding.
Yeah, we're bringing.
Are you doing?
We're preparing a suit in federal court against
on
the
those
judge.
issues specifically.
Exactly on these issues, on liberty interest,
Thank you.
and asking for damages from court officials.
Go ahead, Chief.
Representative.
Thank you. Mr. Vandenberg, I'd like to go back to the statement you just made 3 minutes ago. How can a guardian ad litem take away your liberty, change your visitations, or any of the things you enumerated there without the consent of a judge?
You're right. The judge makes the order. He follows the recommendation. And the difficulty with that, again, according to a case, Ross versus Godwall, the recommendations of a guardian ad litem should or will not have, shall not have any greater weight than anything else in a proceeding. So it should not have any greater weight than what the parents say. Yet, on a practical level, whatever a guardian ad litem says, that's what the judge does. The
There's
judge.
a generalization that can't probably be sustained from one judge to the next, though, wouldn't you agree?
Well, in my case, that's definitely the case. I know that. And that's just what I'm saying. That relates to the other cases I've been looking at. The recommendations of a guardian ad litem are set in place by a guardian. The judges follow those 99% of the time. It's very hard to get those things undone.
Representative Agar.
Thank you, Mr. Chairman. But just for the record, you do not have that federal suit going on as of right now, is that correct?
That's correct.
Thank you.
Representative Morgan.
Yes, there's an alternative to having the judge impose the plan, which is of course for the two parents to agree to a parenting plan and arrangement on their own. So was that ever pursued in your case?
Yes. We just agreed for many, many, many years. Then my ex-wife met her live-in boyfriend now, and within a month of that, all the legal proceedings started against me.
All right, we're going to the recommendations portion. And I'm going to, at the request, and it sounds like the consensus of the committee, strike point C out of the last point, under the additionally portion. It's Ms. Hamilton's, the points regarding Ms. Hamilton and C will be stricken with the agreement. Strike the bottom, that's from C down.
So, right back.
There's two.
And
But
we'll
they're almost
move on.
Just take a 2 minutes.
Yeah, let's take it, folks, let's take a 3-minute break. I see that we're missing people anyway, so if you'd like to take a break, you can head down, get a drink of water or whatever. 5-minute break, this may be, I think we can finish.
Can't get a beer that quick.
What?
Can't get a beer that quick.
There's a keg in the bathroom.